thinks I've gone on too long or not. I think it's hard. No one could really argue that this isn't a critical witness to either and or both sides of this case. I do have to tell you that we just object to having to question him further on Zoom. And I don't think that anyone can say that I didn't try my best to complete it. I think we would have no objection to having him come back at a different time, a different day. And I see your reaction, Judge, but Zoom with this many documents. No, but just this many documents, I just think he knew that he was going to be an expert in this case. He's getting paid $750 an hour. Find a time when he can come back.
Your Honor, we addressed this up front as to whether we were bringing him in person or going to do the entire part on Zoom. We addressed the fact that he would only be here for one day. Would they be able to do that? Otherwise, we would have just left him in Tennessee and done it via Zoom. I mentioned the fact that he's an ICU doctor, has patients, which he said he has appointments for tomorrow, and that he is the caretaker of an adult brother who has Down syndrome, and so can't be away from home for long periods of time. And the defense at that time indicated that we thought we could get it done in a day, and if not, finishing it up on Zoom would be appropriate. The one thing they had asked was that they have the equal amount of time in person, which they did, Your Honor. In fact, I believe they had a few minutes more than I had.
Your Honor, I can just say that I did not agree to where I am today. All I can tell you is what I'm telling the court now on behalf of Dr. Husel is I think this witness needs to continue in person. I can tell you that if the state had proposed ever to initially call him by Zoom, we would have objected to Dr. Ely being called on Zoom. Dr. Swanner, prime example, we litigated that issue well in advance. He's sick. We understood that. We had lots of options, and we elected to do a Zoom with Dr. Swanner from start to finish. We know that. This is different. This is it's hard to imagine they wouldn't say or concede this is their biggest witness. I did my best to get through it. There are 14 patients. I did not try to linger. I'm like, the whole team's trying to work with me here. So I don't know when it is or when he can come back, but he is being paid $750 an hour, and I would ask that he be brought back for the remaining cross and any redirect, which I would imagine would be of length. And it just doesn't seem unfair to me with a man's life on the line.
Okay, first things first. I've listened to both sides. We went over this last week as the solution. Now, if you're saying that you absolutely have to have him live, tell me why.
Well, Your Honor,
because you've had a chance to confront him, okay? The Zoom isn't going to change the testimony in any way.
Your Honor, I think as indicated by the mess that is created around me is this is a very document-intensive witness. The Zoom becomes fragmented with a lot of documents. It's also, as evidenced by the last 30 minutes, the kind of case where he says one thing, we instantaneously pull a document. It's not like I had all these documents prepped, right? We're trying to be responsive to the best of our ability. I'm going to own, if you say we discussed this already and you say, Ms. Venasci, you didn't object like you are previously, I'm going to tell you I didn't. But I didn't really know until right this minute and this afternoon and today that Dr. Ely would present as he does. And I think he should be here in person.
Okay, was he ever deposed in the civil cases?
No.
Ms. Sawyer?
Again, Your Honor, this was specifically addressed last week. I named Dr. Ely as the witness that would be done. They agreed we could do it one day live and then finish up with Zoom. Dr. Hagris, we both introduced a ton of exhibits with him via Zoom, and it went fairly smoothly. I don't see any difference here with Dr. Ely. And again, this was addressed up front. And we had agreed previously that any witness who wanted to testify via Zoom due to the conditions and everything else would be acceptable. We brought him in specifically because of what his role is, with the understanding it was one day, and they agreed, As long as they got equal time that the state had, we could finish up on Zoom.
Anything else?
Only because we're allowed to speak one at a time. Mr. Bias handled this issue with the court when it was first addressed, and I believe that his objection was that as long as we were live, if they were on Zoom for redirect, we had no issue with that. I just want to say again, I clearly sped up towards the end, and I did so, and I'm putting this on record. It's not a good look optically in front of the jury with me rushing through patients. It's not, but I wanted to do as much as I could in person. I'm just telling you, Your Honor, let's just do this right and do it best practice. I don't care when he comes back. We're going to be here for 8 weeks.
Your Honor, for the record, we addressed this twice. Once with Ms. Menashe, where she said it was acceptable, and one with Mr. Bias, where he said the same.
See, he's different than Dr. Hagris.
Correct.
Okay? Dr. Hagris was a fact witness. This is an opinion witness. I want a minute to think about it.
Well, Your Honor, he's expecting a Zoom link for 9 in the morning. How do you want us, we'll need to get Darcy.
I don't know yet, okay?
Okay.
Give me a minute to think.
Okay, I'm sorry. I thought you wanted to think overnight.
No.
I apologize, Your Honor.
No, I want to think this through for a second. Plus, I want to stretch my legs. Okay, we're off the record for a minute.
Yeah, I see both of you sticker over here as well on the floor.
Did you get the Tracy Young that I marked?
What do we know is Healy fixing?
You come forward and take Mr. Zion's seat so I don't have to look across the room?
I can stand next to him, Your Honor.
Okay, that's fine. Ms. Menashe, how much more time do you have in examination?
Your Honor,
Roughly, I know you can't have.
I don't think I need to.
You don't have to give me a foreshadowing.
Yes.
I can only imagine, if it were me, that what I would be asking, but that's beside the point.
Yes, I haven't yet gone through my notes and circled back about other things that he said that were not either patient-specific or in line with my intro comments about his articles and his accuracy, et cetera. So yes. And I also don't want anyone to say that I've held myself to an hour. So I just want to say that as well.
In my mix, I'm guessing it's another day on the stand between the two.
Your Honor, it'll depend on the rest of her cross, because right now I don't have much more than maybe an hour on redirect, if that.
Okay. Were there durable power of attorneys and living wills in the medical records?
In a few of them, I believe there are, Your Honor. I don't know about every single one of them. Diane, do you recall? I don't remember them all.
Actually, power of attorneys in the medical records. I don't think in all, but in some.
Some, yeah.
Some were there? Because you alluded to it twice.
Oh,
Yeah, there are a few of them
there are
definitely in
definitely a
there.
few.
Okay, but you call them power of attorneys.
I'm sorry?
They're durable power of attorneys.
Oh. Okay.
Sorry. Difference, they're a different thing under the statute.
Okay.
Okay.
Well, that just added an hour and 2 minutes to clear that up.
I hate doing this to the jury, but let's bring him back live another day in the future. You coordinate his calendar,
Okay.
okay?
And Your Honor, I know it will not be March 11th through the 18th because I will not be here to handle him then.
Okay, well, we're kind of stuck,
Yeah.
okay? I mean, I understand the fluidity, I understand the situation, okay? He's a very important witness. I think live in the courtroom is important. So I'm going to agree with the defense on this one. You can tell him that I changed my mind. I don't care. But in all fairness, they've watched him live the whole time. And I think it's also important they see him live during a redirect.
Your Honor,
So-
again, I just note our objection because this was addressed twice in advance. So I appreciate what you're saying, though. Thank you.
I understand trials are fluid. Okay, they ebb and flow. Okay, so we're going to go with that.
Okay,
So have a new witness on tomorrow morning.
absolutely. And I will give him a call and let him know what's going on.
Okay, and, we'll try to adapt to him. If we can only fit him in on a Friday, we'll give up one of our Fridays to get him done.
Let me call, he probably,
But tell him it's not my preference.
sure, absolutely.
Okay.
I will call and let him know not to expect Zoom tomorrow, and I'll work with him once he gets back in his office to figure out a day.
Okay. Anything else for the record?
Yes, Judge. I apologize. I realize it's late in the hour, but I feel I have to bring this to the court's attention. During the cross-examination of Dr. Ely, at the point when we were discussing the patient, Bonnie Austin, Ms. Menashe was going through an exchange with Dr. Ely in reference to Dr. Brady. At that time, the prosecutor, Mr. Zion, decided it was prudent to mention and say out loud to Ms. Menashe while she was cross-examining Dr. Ely that Dr. Brady is going to testify. We can just simply ask him.
He did do that.
This is the second incident that we've had where prosecutors are blurting out from counsel table extrajudicial statements that are highly improper because they are clearly being heard by the jury. In essence, his comment basically is don't listen to this line of questioning because Dr. Brady's going to testify. Yesterday, or the day before, or the previous incident number one, it was the defense lawyer is wrong, therefore you don't trust him. I don't think the court's admonition to the prosecution was, I guess, a deterrent enough to prevent this incident from happening. Aside from it being highly improper, this is William Husel's only jury in his day in court. He deserves a trial where prosecutors are not engaging in this type of behavior where they're making statements of their, either their opinions or what their interpretation of the evidence is, it is highly improper, and I think it warrants at this time a much clearer admonition by the court, not only to the prosecution, but to this jury, that they are not to be listening to what the prosecutors say at counsel table. I recall your I guess your curative was general in nature, but one time we have a slip up, 2 times it's a pattern, and 1 time alone is enough, in my opinion, to convict a man if there's anything that sticks with the juror's mind, and it's just simply not acceptable to the defense. I don't know where that type of conduct is acceptable, but I certainly don't think it's acceptable in this court, and I would ask that the court address the matter a little bit more stringently this time around.
Okay, well, if we're going to go down this line, what's your empirical evidence that you're prejudiced?
I'm sorry?
What's your empirical evidence? What are you basing, you saying you're prejudiced?
The prejudice is that the prosecutor is in essence saying, don't listen to this line of questioning because Dr. Brady is going to take the stand and you can simply ask him. Now, his comment, of course I'm extrapolating on that, on what he said, but his comment was, Dr. Brady is going to testify, we can simply just ask him. And that's in essence what he is saying when he makes a statement like that. Now, if that's his personal belief, that's fine. He's more than entitled to keep that. Or to
you're
whisper.
upset because he doesn't want them to listen to him because the doctor's coming on.
Correct.
Their witness.
No. Ms. Menashe's questioning to this witness.
Well, I think everybody knows that Ms. Menashe knows how to ask questions. Okay? So, okay. Shazan.
Yeah, Judge, the mistake was your rule about the person that has the witness makes the objection. If that had been my witness, I would have stood up when she solicited hearsay about what Dr. Brady saw or knew. I would have said, objection, Your Honor. We can hear from Dr. Brady to come in. This is hearsay. Like I would with any other objection. And then if we needed to approach to talk about it further, we would have. That was my mistake because it should have been Ms. Sawyer's objection. So I apologize for that. And so that was a mistake to say objection. And that's how practicing in front of you, objection, you state the reason for it, and that would have been the objection. So I don't think there was anything inappropriate other than it wasn't my turn to make objections. So
on the floor.
I would also reiterate what the court says. I mean, it gets heated over here. I mean, they get heated over here too. If we're going to put things on the record, and you've made note of this too, Judge, in previous things, the noises and I'm not trying to impute anything on the defense, but when he was talking about, things happening in a night, I mean, I get it. It's an emotional thing and things blurt out, but it's nothing that warrants any type of sanction or any type of anything to the jury. I mean, the jury knows what's going on here. So that's just for the record from the state's point of view. Thank you.
Mr. Baez.
I just simply, again, I guess Mr. Zion's retort to my statement is that he would have exercised a speaking objection and given some commentary as to why he thought that line of questioning was improper on Ms. Menashe questioning a witness about what the medical records say. So in essence, don't pay attention to these medical records. Dr. Brady is going to come in and testify. Again, I don't see how it's completely improper. If the prosecutors have a specific incident that they want to bring up, they're free to do so. But we're not sitting 3 feet away from the jury in this case. They are. And if they're going to sit that close to the jury, they need to control themselves. And that's just simply put. And that's no shot at these prosecutors. Personally, I like them all. But I I don't like them enough to allow them to make extra comments to this jury while my client is standing trial for murder. So I think it needs to be addressed, and this is the second time we've had this come up. What are we going to wait for, a third or fourth, until we get to the point where perhaps Dr. Husel's not getting a fair trial? I simply don't want that to happen, and I don't want us to be in that position. I think this needs to stop, and it needs to stop immediately. And that's my 2 cents, Judge.
Okay. Mrs. Zion, you were not on the floor. You know my rule.
And I apologize. So that's why I kind of like, but had I been, that's all I was trying to do is.
You know you don't do walking objections with me.
What's that?
You don't do the walking objections. She should have objected hearsay, and that'd been it.
Yeah, and
Okay? But that's between you two. It shouldn't have come out like that because you went above and beyond. We won't have this behavior again.
I apologize, Your Honor.
Okay?
It's just
Because
a new
next
thing.
time I'm going to start sanctioning.
Yes, sir.
Okay?
Yes, sir.
That goes for everybody. If you're not on the floor, you don't talk. It's the benefit of the jury, okay? They're the ones who have the right to hear this, and if I got a bunch of people talking, irregardless, if you guys need to speak, then let's go sidebar. But one person's on the floor, and the behavior stops, okay? 2 days in a row. The last one was last Friday. Okay? Unless you're going to make some motion at this point in time, I don't think it's there. I think we can cure it with this. I don't know the extent with the jury. I might have to do something. Here I'm playing Russian roulette with 5 bullets. If I mention the jury tomorrow that blurted out yesterday, am I re-informing it? I don't think you want that.
I understand the court's position, and I'm not trying to make more of this than what it is. So what we will do is we'll take the evening to discuss it amongst the team, and if I feel I need to make a formal motion, I'll do so in the morning. If not, I appreciate the court's attention to the matter.
Okay. Anything else?
Nothing further from the defense.
Ms. Sawyer?
Nothing on behalf of the state, Your Honor.
Okay, have a good evening. 9 o'clock promptly. We'll start. Don't roll in here at 5 till. I have to go to the bathroom.